Bismillahirrahmanirrahim. Assalamu alaikum wa rahmatullahi wa barakatuh. My name is Ghulam Sajjad Gopang. I am the youngest advocate in the history of Supreme Court of Pakistan. I am MBA Finance first position holder from IBA University of Sindh Jamshorus. I am LLB first position holder from Quaid-e-Azam Law College Nawabshah Sindh. I am the first advocate Supreme Court in the history of District Nawabshah Sindh, and I am practicing at Supreme Court Islamabad. On special request of you friends, today's lecture is regarding criminal cases, and the topic is acquittal of accused under section 249A of the Criminal Procedure Code and 265K of the Criminal Procedure Code, and the parameters and the grounds of quashment of FIR and quashment of proceedings through constitutional petition under Article 199 or an application under Section 561A of the Criminal Procedure Code by the Honorable High Court. First of all, when the FIR is registered, case is investigated and is challenged in the trial court. Either accused is to be discharged under section 169 by the investigation officer or is being challenged in the court. Now, if the learned magistrate accepts the challan and if the case is triable by the learned magistrate, then if the accused is aggrieved, he can file an application after framing of the charge under section 249A in those cases which are triable by the magistrate. For an instance, injury cases, 337 cases, 337 PPC cases, 392 PPC cases, robbery cases, 489F cases. In such applications, if accused is aggrieved, he has a remedy to file an application under section 249A CRPC that the ground should be that the charge against the accused is groundless and there is no probability of the conviction of the accused. So, at any stage of the trial court, the learned magistrate can acquit the accused under section 249A CRPC. And the second point is 265K. 265K means, for an instance, the case is triable by the session court, district and sessions court, or additional judge, session judge court. Now, in a murder case or any case which is triable by a session court, if challan is submitted against the accused and he is aggrieved, is not satisfied with the investigation and the case, the evidence, after framing of the charge, he has a remedy to file an application under section 265K CRPC, and on the ground that there is no evidence against him, the charge against him is groundless, and there is no probability of the accused to be convicted. Therefore, at any stage of the case, the learned sessions court is empowered to acquit the accused under section 265K of the Criminal Procedure Code. It means that accused must have a solid ground, a very, very powerful ground. Until and unless, for instance, accused is charged under section 489F, case is pending in the court of magistrate. Check is not issued by him. Check is issued by principal co-accused. There is no agreement in which he is the witness or he is the guarantor. Then he has a good case for acquittal under section 249A, and there are so many chances that the learned magistrate will acquit him under section 249A. In 265K, if the case is murder case and the accused is not nominated in the FIR, he is nominated by the co-accused, who in the custody of police, as recorded in the statement under section 161, that with me on the date of incident when I committed the murder, Mr. So-and-so was with me, accompanied with me, and he facilitated me. With the help of him, I committed this murder. If there is no any other evidence, again if the case is challaned, that person, although is nominated in that murder case, but as there is no evidence to connect him with the alleged offence, and the statement of co-accused is inadmissible in the court of law, as I have delivered lecture on the point of law of evidence. You can see that lecture in detail. On that ground, the Sessions Court is empowered, and it's a good case for that accused, that at any stage of the trial, the Sessions Court can acquit the accused under section 265K from that even murder case. Now another point is Quashment of FIR, how and why the accused should approach the Honorable High Court for direct jurisdiction for straightaway quashment of the FIR. It is an extraordinary remedy that you are availing, and it is a very, very difficult relief that you are seeking. In this regard, PLD 2004 Supreme Court 298. If you are complainant in that case and the accused has filed application for quashment, writ for quashment, then PLD 2004 Supreme Court 298 is very, very important. It says not only the accused must have approached and availed the alternate effectuous legal remedy under section 249A, but even if the application under section 249A is dismissed, then again writ is not maintainable. PLD 2004 Supreme Court 298 says, Honorable Supreme Court has held that where an application under section 249A of the Criminal Procedure Code was dismissed by the trial court, the proper remedy for the aggrieved person was under section 439 or 439A of the Criminal Procedure Code, as the case may be, and not under section 561A CRPC, as the provisions of 561A CRPC were not meant to provide an additional or alternate remedy. Exercise of powers under section 561A by the High Court in circumstances was legally untenable. These were the principles. So, most of the cases are in favor of the complainant when the quashment is sought. But today I will teach you, there are several judgments of Honorable High Court and Honorable Supreme Court on this ground, that if the further proceeding of the case appears to be abuse of process of law, then High Court can directly quash the proceedings. High Court can directly quash the FIR. In this regard, PLD 2013 Islamabad of Islamabad High Court. This is the judgment of Islamabad High Court. PLD 2013 Islamabad High Court, page number 75. It says, no certificate had been issued by the federal government for the prosecution of accused in Pakistan. Offence was allegedly committed in the year of 2003. FIR was registered in the year 2005. No doubt the court in Pakistan had the jurisdiction. However, for trial of such an offence, certificate from the federal government was required. proceedings pending against the accused were quashed accordingly. Now, straight away, no application under section 249 or 265K was filed, but again it was quashed. Another landmark judgment of the Honorable Supreme Court in favor of Quashment. 2011 SCMR 863. It says, High Court wide impugned judgment had converted bail application of the accused. This is a very interesting case. Bail application was filed in the Honorable High Court, and the Honorable High Court converted that bail application into quashment of proceedings, and not only converted it but allowed it, and proceedings were quashed. That order was challenged before the Honorable Supreme Court, and the Honorable Supreme Court was pleased to maintain that order, and Honorable Supreme Court was pleased to hold that High Court wide impugned judgment had converted the bail application of the accused respondent into petition for quashment of proceeding and allowed the same FIR as well as other material on the record had revealed that accused was an employee of Civil Aviation Authority who happened to be on duty at the airport at the relevant time. Mere fact that the accused was standing close to other accused therefore would not saddle him the responsibility of abatement of commission of the alleged offence. No incrementing evidence was available against the accused. Impugned judgment was just and fair, and no exception could be taken on her technical grounds. Leave to appeal was declined. This was case of PIA, Pakistan International Airline and Civil Aviation Authority, in which Honorable Supreme Court maintained the order, in which Honorable High Court was pleased to quash the case, quash the proceedings entirely. Afterwards, another case. This is in which bail application was converted into appeal. This is PLD 2012 Lahore 406. PLD 2012. PLD 2012 Lahore 406. Accused, after registration of the case in Department of Proceedings, had been dismissed from service and in appeal of dismissal were converted into major penalty. Notwithstanding was to be converted from the accused, and continuance of the present proceeding in the case against him would amount to sheer abuse of process of law and the court. Bail application was consequently converted into petition under section 561A CRPC, and the FIR along with its emanating proceedings were quashed in circumstances. So there are precedents. There are several precedents in which the FIRs have been quashed even along with the entire proceedings. Although it is a very, very difficult subject, but the judgments are in that favor as well. Now, let me give you another example. This is 2014 MLD 524. Complainant alleged in FIR that accused received amount from her and breached the terms of contract validity. Breach of contract, if any, in absence of dishonest intention, did not constitute criminal offence under section 420 of the Pakistan Penal Code. High Court, in exercise of inherent powers, quashed the proceedings and application for quashment was allowed. Today I will refer you the book of quashment under section 561A of CRPC and article 199 of the Constitution. This is Popular Law Book House. Sayyid Asif Ali Bukhari and Gul Hassan Ghazi, these are the advocates of the High Court. Like this video and share it so that, and subscribe my YouTube channel so that my lectures will be easy for you to listen and understand the topics of law. Thank you very much. Allah Hafiz.